أصحاب السعادة
Excellencies, distinguished delegates, ladies and gentlemen, it is my great pleasure to open the 8th session of the conference, where we will examine item 2 of the agenda on the review of the implementation of the convention. We are here today in accordance with the terms of reference adopted in Resolution 3/1 of the Conference of the State Parties to the United Nations Convention Against Corruption at its third session held in November 2009 in Doha, Qatar. This resolution marks the historic adoption of the review mechanism, the fruit of the same constructive and positive spirit that guided the negotiations of the convention itself and that has characterized the work undertaken since the launch of the country reviews at the first session of the IRG held in June 2010. At its fourth and fifth sessions, held in Marrakesh and Panama City, the conference was able to consider the work of the mechanism. And on these two occasions, the conference adopted Resolution 4/1 and Decision 5/1. Resolution 4/1 endorsed the action taken by the group, and it addressed the funding of the mechanism and ways to overcome delays in the review process and enhance consistency in reporting. It also reaffirmed the important role of technical assistance within the context of the mechanism. Decision 5/1 saw the conference task the group with collecting and discussing relevant information on the assessment of performance of the mechanism's performance following the completion of the first review cycle, and to include an agenda item in future sessions allowing for discussing such information. In addition, the resumed sixth session of the Implementation Review Group was concluded earlier this afternoon. I beg your pardon? It was concluded earlier yesterday afternoon. And the Secretariat will provide an overview of the outcomes of the session in its briefing. Moreover, the report adopted by the group has been made available to delegations in English in their pigeonholes in hard copy. And building on this background, I would first like to draw your attention to the note prepared by the Secretariat entitled, and I quote, Progress Report on the Implementation of the Mandates of the Implementation Review Group, in document symbol CAC/COSP/IRG/2015/CRP.15. This document aims to provide an overview of the conduct of country reviews. In addition, the Secretariat has prepared a note entitled Assessment of the Performance of the Implementation Review Mechanism, contained in document
CAC COSP/2015/6 والتي
This note consolidates the information and suggestions received on the performance of the review mechanism, as well as the outcome of the discussions in previous sessions of the Implementation Review Group on this matter for consideration by the conference. In addition, and for the sixth session of the conference, the Secretariat has prepared a study entitled State of Implementation of the United Nations Convention Against Corruption, Criminalization, Law Enforcement, and International Cooperation. The study contains an in-depth analysis of the thematic findings from the country reviews that had been completed by the time of drafting. The study is available together with the related summary in document
CAC/COSP/2015/5.
In order to facilitate our deliberations, it is now my pleasure to invite the Secretariat to address the conference and to introduce these documents and the main findings. Following the Secretariat's remarks, a panel discussion will be held to encourage constructive discussions on implementation. You have the floor.
Thank you very much, Mr. Vice President. Excellencies, distinguished delegates, ladies and gentlemen, it is my pleasure to also welcome on behalf of the Secretariat the new states parties that have acceded to or ratified the convention since the previous session of the conference. Those states are the Gambia, Germany, Grenada, Oman, South Sudan, the State of Palestine, Sudan, and Tuvalu. Under this agenda item, we will provide an update on three separate matters. First, a progress report on the organization and schedule of reviews. Second, a brief outcome on the resumed sixth session of the IRG, the Implementation Review Group, which concluded yesterday. And third, the overall impact of the mechanism, including further work ahead. To begin with, let me highlight some key statistics of the mechanism. To date, 121 executive summaries have been finalized. 100 full country review reports have been completed. 13 further executive summaries are in the final stages of agreement. And this means that they're either with the reviewing states parties or already with the state party under review. 148 direct dialogues have taken place, and 163 responses to the self-assessment checklist have been received. 50 full country review reports are available on our website. Turning now to the organization and schedule of reviews, I would like to give you some further details on the various categories that we've been discussing. First, on the self-assessments. As I mentioned, 163 responses to the self-assessment checklist have been received. For states under review in years 1 and 2 of the mechanism, all such states have submitted their responses to the self-assessment checklist. For states under review in year 3 of the mechanism, all but 2 states under review have submitted their responses. With regard to year 4, 62 out of the 73 states under review in year 4 have submitted their responses to the self-assessment checklist. 9 out of the 11 states that have not yet done so are new states parties. With regard to direct dialogue, I would like to inform you that of the 176 states parties under review, and this includes our most recent states parties, 148 have opted to include further means of dialogue in their review. 136 country visits and 12 joint meetings have taken place so far. Several other country visits are in various stages of planning. Approximately 85% of states involved other stakeholders, including civil society organizations, academia, and the private sector in their country visits. As I mentioned, a total of 121 executive summaries is available to you. 113 of them are available in all 6 official languages of the United Nations, and an additional 9 executive summaries are available as conference room papers. Furthermore, since the inception of the review mechanism and continuing during the period under review, UNODC has provided training and workshops on the Convention, the review process, in particular the self-assessment checklist, and the follow-up to reviews. To date, Secretariat-led trainings have resulted in over 1,700 anti-corruption practitioners being trained. We're also aware that these trainings have a multiplying effect as knowledge is replicated nationally, and so it is safe to assume that well over 2,000 practitioners have to date received some form of training on the Convention and on the review mechanism. Specifically, a number of states have sought assistance from UNODC to prepare themselves for their reviews and to strengthen international and interinstitutional cooperation. Many states have also reported that such interinstitutional cooperation has been strengthened as a result of their review. The global and inclusive nature of the mechanism, in addition to the funding received, has also enabled a strong participation and strong involvement of least developed countries and developing countries. And my colleague will now provide you with a brief overview of the outcome of the resumed session of the Implementation Review Group. Thank you.
Excellencies, distinguished delegates, as was mentioned, I would like to provide you with a brief update on the main outcomes of the resumed 6th session of the Implementation Review Group that was held on Tuesday and Wednesday, November 3rd and 4th, in order to continue and to conclude the agenda items from the 6th session of the group that was held from June 1st to the 5th, 2015. In accordance with the decision to review all states that became parties after the launch of the review cycle during the 4th year, there have been 73 states under review since June 2013. A drawing of lots for the 2 newest states parties was held at the resumed 6th session of the Implementation Review Group. Sudan and Guyana were drawn as reviewing states parties for the Gambia. Turkmenistan and Grenada were drawn as reviewing states for Tuvalu. A drawing for the provisional reviewers for Grenada was also conducted, as well as for Guinea. And in this respect, Antigua and Barbuda and Germany were drawn as the provisional reviewers for Grenada, and Cameroon was drawn as provisional other reviewer for Guinea. Before the most recent drawing of lots, to date, 32 states had performed 3 reviews. 115 states had performed 2 reviews. 22 states had performed only 1 review, and in addition, 7 states had not yet performed a review, most of those being new states parties. Following the oral update provided by the Secretariat on the progress report during the group's session, speakers discussed the work that was carried out by states under review and reviewing states parties, including the exchange of experiences that was obtained during the review process. At its 5th session, the conference established in Decision 5.1 that the Implementation Review Group should begin promptly to collect, with the support of the Secretariat, and to discuss relevant information in order to facilitate the assessment of the performance of the mechanism in accordance with paragraph 48 of the Terms of Reference following the completion of the first review cycle. In addition, it decided that the group should also include in its agenda an item allowing for the discussion of the information collected. Thus, at the resumed 6th session of the Implementation Review Group, as per the guidance received from the conference, this information was discussed under Agenda Item 3 on the performance of the review mechanism. Regarding the assessment of the performance of the mechanism, including the draft revised self-assessment checklist, the group referred to the mechanism as a useful tool for furthering the implementation of the Convention, and speakers shared their experiences generally during the review process. It was agreed that the terms of reference of the mechanism continue to provide an adequate framework for the operation of the mechanism, bearing in mind its guiding principles. Speakers underscored their readiness to launch the second cycle of the mechanism in accordance with paragraph 13 of the Terms of Reference. Several speakers welcomed the development of the draft revised checklist and stated that further streamlining of the draft would be desirable, while others expressed their preference for continuing to use the version of the checklist used for the first review cycle. The group also considered its items on technical assistance and financial and budgetary matters. Excellencies, distinguished delegates, I'd now like to say a few words on the impact of the review mechanism and the further work that lies ahead. The measurable outputs of the mechanism go far beyond the stated goals and expectations that drove the adoption of the Terms of Reference during the third session of the conference. The implementation of the Convention has generally been strengthened through the mechanism, and states have often seen their country review process as an opportunity to galvanize reform efforts and to advance domestic coordination, including through national action plans and anti-corruption strategies. The process has enabled engagement with stakeholders, which was considered especially important in raising broad public awareness of the Convention and of the review mechanism. On the basis of the challenges identified, a large number of states parties reported on specific steps that they had taken both before, during, and following the completion of the review process in order to address the review recommendations and to advance the implementation of the Convention. For example, the findings of the reviews have helped to enhance domestic coordination across the institutions tasked with preventing, investigating, prosecuting, and adjudicating corruption. In a number of states parties, national steering committees or intergovernmental task teams had been created to coordinate the implementation of the Convention and the review process itself. That coordination was described as indispensable for the effectiveness of the process. In a number of countries also, national action plans had been created to follow up on review recommendations and to coordinate activities. And the important role of the mechanism in enhancing implementation and cooperation among states was noted. Since the launch of the mechanism, an increasing number of states have sought assistance from UNODC in drafting new legislation or in commenting on draft bills. In the same context, wide-ranging support was provided to improve states' capacities to prevent, detect, investigate, and prosecute corruption. In designing national reform measures, a number of states parties had been oriented by the good practices and the lessons learned that emanated from the reviews of other countries and that had been identified in the publicly available executive summaries and, in some cases, the full country review reports. Also in the area of international cooperation, states parties reported on legal and policy reforms that emanated from their review recommendations. This included an increase, for example, in one state party in the number of international cooperation cases that had been registered following the adoption of a new law on mutual legal assistance, which also contained specific procedural requirements, and that had been created on the basis of the review recommendations. States also reported on enhanced enforcement action, which led in many cases to the conviction of offenders in high-level corruption cases and the successful recovery of significant amounts of proceeds of corruption. Several countries reported using the experience of the reviews to strengthen their domestic data collection and data management systems, which was seen as a positive outcome of the reviews. Country reviews also helped states to identify technical assistance needs and to coordinate the assistance provided by development assistance partners. Finally, the launch of the mechanism had created a renewed momentum for states to ratify or accede to the Convention. The outcomes of the reviews generally constitute an unprecedented knowledge base on anti-corruption measures across all regions. Indeed, the review process presents us with a global assessment on the state of implementation of the two chapters under review, and also the first global benchmark against which trends can be assessed and progress can be measured. In this respect, I'd like to note that the TRAC web portal enables information that has been collected and analyzed to be made widely available. It's had over 14,000 visitors by over 10,000 unique visitors since January 1st, 2015. In order to address areas for improvement, especially with a view to preparing for the second cycle, the Secretariat has sought to simplify and refine the self-assessment checklist. Starting from December 2013, we've solicited comments from states parties on the draft revised checklist for the review of chapters 2 and 5. 13 states parties availed themselves of the opportunity to provide comments in the first round of consultation, while 19 states parties did so in the second round. The Secretariat then incorporated these comments into a new draft revised checklist for the second cycle, which was made available to the conference and also to the group. Finally, as was mentioned by the Vice President, we would draw the attention of delegates to the study entitled State of Implementation of the UN Convention Against Corruption, Criminalization, Law Enforcement, and International Cooperation. And we look forward to the outcome of the panel discussion on review of implementation. Thank you, Mr. Vice President.
I thank the distinguished representatives of the Secretariat for the valuable information that they have offered. This information is important and encouraging, frankly, for our proceedings this morning. I now invite Mr. Ioannis Androulakis, lecturer in criminal law and criminal procedure at the Faculty of Law of the University of Athens, to present his statement. You have the floor, sir.
Thank you very much, Mr. Vice President. The mechanism for the review of the implementation of the UNCAC offers the opportunity to collect and disseminate an unprecedented wealth of information, drawing from the experiences gathered and lessons learned by states with different legal traditions and varied levels of economic and institutional development. The study, entitled The State of Implementation of the UNCAC, is based on that information and contains a comprehensive analysis of the implementation of chapters 3 and 4 of the Convention by 68 state parties at the time, reviewed at the time of drafting. More specifically, the study has been prepared in order, firstly, to identify and describe trends and patterns in the implementation of chapters 3 and 4, focusing on systematic or, where possible, regional commonalities and variations. Secondly, to highlight successes and good practices on the one hand and problems and challenges on the other. And thirdly, to provide, to the extent possible, an overview of explanatory observations on the implementation of the provisions of the Convention, based on the significant input and findings of the states parties under review and the governmental experts who contributed to the country review reports. As regards the main findings of the study, it has identified an evolving process of legislative change in the anti-corruption legal frameworks of the majority of state parties over recent years, which has led to notable advances in the direction envisaged by Article 1 of the Convention. Combating corruption is ranked among the highest governmental priorities in many state parties, and substantial resources are devoted to it. The Convention has triggered concerted and wide-ranging efforts to assess the anti-corruption regimes of state parties, identify areas where national capacities are lacking, and plan for future action. In some countries, statutory amendments and structural changes have been combined to produce tangible results in terms of legislative and regulatory enforcement action, indictments and convictions, even in cases of high-level corruption, as well as strong cooperative networks for extradition, mutual legal assistance, and law enforcement cooperation. In this context, the Convention has already played a significant role and continues to serve as a fundamental basis for the establishment of effective anti-corruption regimes. The impact of the Convention is perhaps more apparent with regard to Chapter 3. Several countries have drafted or introduced new legislation for the purpose of fulfilling their criminalization and law enforcement obligations. For example, widening the range of and increasing the penalties for corruption offenses, introducing the offense of foreign bribery, criminalizing self-laundering, introducing a regime governing the liability of legal persons, expanding the protection of witnesses and victims, and strengthening the mandates and functions of specialized anti-corruption authorities. In this context, concepts that were new in some jurisdictions, such as illicit enrichment, were analyzed in order for state parties to gain an understanding of their content and enable the implementation of the relevant convention provisions. All in all, the country reviews of many state parties were able to identify the criminalization of a wide array of corruption-related conduct as a significant strength of national legislation. Numerous good practices were also identified. Having said that, substantial challenges remain. These range from problems of the most rudimentary nature, such as practical impediments owing to lack of experience, resources, and training, to gaps and deviations regarding the formulation of complex criminalization provisions. Although problems were detected in varying degrees in respect of all relevant provisions, the most notable outstanding issues concern mandatory measures. These include, for example, active bribery of foreign public officials and officials of public international organizations not being established as an offense, and the apparent ineffectiveness of existing legislation, inadequate practical capabilities of competent authorities with regard to the enforcement of the provisions on the laundering of proceeds of crime, and the limited application in practice of measures to establish the criminal or non-criminal liability of legal persons. With regard to measures to enhance criminal justice, significant problems relate, for example, to the requirements to establish adequate sanctions for corruption-related offenses, take measures to enable the identification, tracing, freezing, and seizure of assets, and create adequate normative frameworks for the protection of witnesses, experts, and victims. Finally, with regard to law enforcement, the most important challenges relate to the efficiency, capabilities, and independence of specialized authorities, insufficient incentives for cooperation with law enforcement bodies, and a lack of effective interagency coordination and information exchange. Some suggestions for overcoming the gaps identified are highlighted in the individual parts of the study. In numerous cases, it was recommended that new provisions and laws are adopted and that the consolidation of existing legislation and adoption of standalone legislative frameworks are considered, such as those related to the protection of witnesses and reporting persons. Recommendations were also frequently made in the context of Articles 32, 36, and 38 concerning resource allocation and the capacity of anti-corruption bodies and institutions. Another cross-cutting problem regarding the implementation of Chapter 3 appears to be the lack in many countries of adequate statistical data or case law typologies relating to the investigation and prosecution of corruption offenses. As regards Chapter 4 of the Convention, a somewhat different picture emerges. Given its more compact and focused nature, as well as the self-executive character of many of its relevant provisions, Chapter 4 appears to be implemented to a more advanced degree, at least from a theoretical point of view. Many reviews noted robust and well-articulated legal frameworks on international cooperation, a notable array of bilateral and multilateral treaties on extradition and mutual legal assistance, and wide networks aimed at facilitating interstate law enforcement action. The available data suggests that the majority of state parties do not need a treaty basis for extradition or mutual legal assistance. Equally, most state parties confirmed the possibility of relying on the Convention itself as the legal basis for the extradition of corruption offenders, and the vast majority did the same with respect to mutual legal assistance. More importantly, Article 46 has actually been invoked and has served as the legal basis for providing assistance on numerous occasions, even if the numbers of cases are still small. For law enforcement cooperation, state parties rely primarily on treaties or informal arrangements, and in most cases also confirm that they could use the Convention as the basis for cooperation. Most state parties also have the necessary legislative framework to carry out transfers of sentenced persons, conduct joint investigations, or use special investigative techniques under certain conditions. On the other hand, in a number of reviews, it was noted that there was a significant gap in knowledge with respect to the practical modalities of international cooperation, and scarce resources were dedicated to it. Additionally, difficulties arise owing to the lack of open and sufficient communication between requesting and requested states, delays in receiving responses, and even the total lack of response by some national authorities. In view of this, the most significant challenges with regard to Chapter 4 appear to be of an operational nature and concern the adoption of measures to give practical effect to existing legal instruments and simplify international cooperation procedures. Coming now to the last part of my presentation, it should be acknowledged that the implementation review reports are not always flawless. The broad scope of the review process, at least in comparison to other international review instruments and mechanisms, and the multitude of issues raised during its course have apparently, for practical reasons, not always allowed for an in-depth evaluation of all convention provisions. Thus, the information provided by individual countries was often lacking, and some provisions, such as the essentially non-criminal provisions of Articles 34 and 35, did not appear to attract the same degree of attention as other provisions. Moreover, there emerged issues of inconsistency in the way some matters were evaluated by the governmental experts conducting the country reviews. Allow me to refer to just one example. It has to do with immunities for reporting persons. In several state parties, the possibility is foreseen of granting immunity from prosecution to persons engaged in bribery, trading in influence, or money laundering, who voluntarily report their criminal involvement within a short period of time or before the authorities receive information about it from other sources. The Convention does not exclude giving such incentives to enable cooperation with law enforcement authorities. On the contrary, it outright encourages them, given the context of Article 37, paragraph 3. Nevertheless, some evaluators have expressed reservations regarding total immunity practices and have issued recommendations to ensure that appropriate sanctions are imposed in all cases. On the other hand, other reviewers expressly identified the possibility of relieving the reporting person from criminal liability as a good practice and noted that thanks to these provisions, the relevant investigations had been simplified and significant results had been achieved. In cases where there are such disparate opinions, the issues under review merit further examination, as do issues such as the degree to which a country is bound to adopt the Convention text and structure, the application of the concept of factional equivalence, the role of Article 30, paragraph 9, and also the extent to which an authoritative value should be accorded to interpretations adopted by other review mechanisms. I would like to conclude this presentation on a definitely positive and optimistic note. The implementation review mechanism and the work of the implementation review group appear, as we have already heard, to have had a significant effect on transforming the global landscape in the fight against corruption. There is also evidence that the extensive exchange of ideas among governmental experts in the course of the reviews has contributed to desensitizing the issue of corruption, as well as to dispelling some doubts about how to deal with a number of issues pertaining to the substantive requirements of the Convention. Governmental authorities and experts are getting more and more familiar with the UNCAC concepts and requirements, and the country review reports are continuously getting better and tend to adapt common standards of evaluation and of making recommendations. In view of this, I believe we should all be very much looking forward to continuing our work, completing the first cycle of the implementation review for all state parties, and beginning with the next one. Thank you very much.
أشكر.
I thank Mr. Androulakis for this assessment, while underscoring the fact that we will all be optimistic and positive in eliminating the scourge, which is corruption. I now give the floor to Mr. Patrick Moulet, head of the OECD Anti-Corruption Division, Organization for Economic Cooperation and Development. You have the floor, sir.
Thank you, Chairman, Excellencies, delegates. On behalf of the Organization for Economic Cooperation and Development, I'd like to thank the United Nations Office on Drugs and Crime for inviting us to share our experiences on the implementation of the OECD Anti-Bribery Convention. We also want to congratulate the UNODC on the publication of its comprehensive State of Implementation report. We believe it's a very useful tool for countries seeking to better implement their UNCAC obligations. We were honored to contribute to some extent to this report, and I hope that my presentation today will be useful in your discussions on the implementation of Article 16 of the United Nations Convention Against Corruption. Article 16, which, as you know, relates to criminalization, the bribery of foreign public officials, which is the key provision of the OECD Anti-Bribery Convention. The OECD Anti-Bribery Convention has been in force for 16 years, and the Working Group on Bribery, which is the conference of state parties to this convention, will be embarking on its fourth round of monitoring next year, and will be, on this occasion, will formally launch the fourth round at the OECD headquarters through a ministerial meeting on the convention, because we believe that from time to time there is a need to renew and enhance the political commitment. And the meeting will be chaired by the Italian Minister of Justice. Now turning to peer reviews, you'll see that with this slide that over the past 16 years, the Working Group on Bribery has been rigorously and consistently performing its role as the monitoring mechanism for the convention. In addition, last year, in December of last year, the OECD published its foreign bribery report, which is a presentation of an analysis of data emerging from the 427 foreign bribery cases concluded between the entry into force of the convention in 1999 and June 2014. So in my presentation, I'll try to present some of the main cross-cutting issues which have emerged from the phase 3 reviews, and also cross-cutting issues emerging from foreign bribery case law. So the focus of the work of the Working Group on Bribery is really enforcement. Now, of course, when the monitoring work started with phase 1 and phase 2, the key focus was on the legislative framework and the translation of the convention into domestic legislation. Now, with phase 3, a significant part of the reviews have been dedicated to analyzing ongoing and concluded foreign bribery investigations and prosecutions. And this discussion is very much based on lengthy, comprehensive discussions that the evaluation teams have with law enforcement authorities from the evaluated country during the on-site visit. In fact, the working group has identified a main challenge really to effective enforcement. And to be very frank with you, the challenge is the low priority given to foreign bribery investigations and prosecutions. And this is very problematic because in turns, this leads to inadequate resources and capacity for law enforcement. Therefore, in almost every country evaluations, the working group on bribery has called, in the form of recommendations, has called for the allocation of adequate human and financial resources to law enforcement authorities, along with training and capacity building for investigators and prosecutors in complex economic crime investigations and prosecutions. A specific issue which has arisen in the foreign bribery offense, both in the law and its application and in its application in practice, is the issue of the interpretation of the definition of a foreign public official. And by the way, it is interesting to note that this problem is also discussed in the state of implementation report. And there, for example, to be concrete, the problem is that countries may use the same definition for national and foreign public officials, and therefore they may omit certain categories of official which are required in the convention definition. For example, the officials of public international organizations and the officials of state-owned or controlled enterprises, SOEs, creating therefore loopholes in the framework for combating bribery. Another problem is the ability to hold perpetrators liable for the acts of the intermediary. That is to say, to cover the issue of the bribes paid directly or indirectly to foreign public officials. The consequences of the laws which inadequately define foreign public officials and the liability of the intermediaries means serious consequences, that in fact there might be a risk of foreign bribery going unpunished. And you see from the foreign bribery report, and with some data reproduced here in the current slide, you see from this report that the majority of cases involve bribes paid through intermediaries, 71%, and most commonly to SOE officials. Another issue which I think you highlight in the State of Implementation report is the question of facilitation payments. In 2009, the OECD adopted a recommendation, an anti-bribery recommendation, which recommends that countries periodically review their policies and approach on small facilitation payments and encourage companies to prohibit or discourage the use of such payments. In fact, 2 parties to the Anti-Bribery Convention still have a facilitation payment exception or defense to the foreign bribery offense, and therefore both countries have received recommendation to discourage the use of such payments. In general, with only 17 out of the 41 state parties having ever successfully concluded a foreign bribery case to date, it's very clear that an enforcement gap remains. Therefore, there's a long way to go before all the state parties to the Anti-Bribery Convention are actively enforcing their foreign bribery offenses. This is why the next phase of peer review of the implementation of the Convention, phase 4, has been designed by the Working Group on Bribery to maintain the emphasis and the focus on effective enforcement. To help bridge this enforcement gap and to promote greater international cooperation in foreign bribery cases, the OECD has hosted biannual meetings of law enforcement officials from state parties to the Anti-Bribery Convention. And these meetings are very helpful, allowing the law enforcement community to meet together and to discuss in confidence issues, trends related to cases, and sometimes cases themselves. Now, we also recognize the need to strengthen the enforcement of anti-corruption legislation around the world. And therefore, the OECD will launch in December next month the global network of law enforcement officials against corruption. This will be the first time that we will gather law enforcement officials from all over the world on the 8th and 9th of December at the OECD headquarters, and this is open to participation from anti-corruption prosecutors from anywhere in the world. So we invite all parties to consider sending representatives to this meeting. Let's turn very briefly now to international cooperation. It was discussed several times, including yesterday afternoon. So without any surprise, during the course of the phase 3 evaluations, the working group on bribery found that in a number of cases, there were unnecessarily delays in the provision of information requested in the context of mutual legal assistance. And also that bank secrecy and the national economic interest remained obstacles to effective cooperation in certain jurisdictions. And a striking fact from this chart here, only 13% of cases were brought to the attention of law enforcement authorities via mutual legal assistance requests. I'd like to turn to another issue which is very important, corporate liability. How to hold companies and not only individuals liable for bribery and corruption. In fact, for many countries, corporate liability for corruption offenses is recent and has only come into existence in the 16 years since the entry into force of the Convention. The phase 3 evaluation process analyzed these corporate liability frameworks in detail for the first time, but not only the laws, also emerging case law. And it's true to say that an effective framework for corporate liability is a cornerstone of fighting foreign bribery. It is a cornerstone of the Convention itself. The Article 2 requires state parties to establish the liability of legal persons for the bribery of a foreign public official. However, the situation is that many countries are still grappling with concepts such as the liability for the acts of intermediaries, including related legal persons. They are also grappling with concepts such as the liability for the company independent from that of the natural persons involved. The issue of the liability for state-owned enterprises, very important, we already mentioned it. And also a new issue, emerging issue, is how to assess pre-existing compliance programs. And this is particularly relevant in countries where the liability of the company can be avoided or sentences mitigated by companies that can prove the existence of such a compliance program. Another emerging important issues is plea bargaining and settlement procedures. The question of plea bargaining and the settlement procedures also arose in several country evaluations, very often in the context of on-site discussions with the private sector. And the private sector often viewed negotiated justice as a means to have a speedy resolution of the cases. So they are keen to promote self-reporting in those cases. In countries where out-of-court settlements and plea bargaining are possible, the Working Group on Bribery consistently recommended that the settlements may be public. This is very important. May be public when necessary and also, of course, in compliance with the relevant rules of procedure. The Working Group recommended that countries make publicly available the main facts, the natural or legal persons sanctioned, the approved sanctions, and the assets that are surrendered voluntarily in the context of such procedures. An important issue which is discussed in the State of Implementation report is that of effective regret. In other words, immunity from prosecutions when an individual or a company self-reports bribery offenses prior to their detection by investigative bodies. This kind of principle can be used in other contexts, for example, in competition law, when issues of cartel and collusion offenses are raised. But in fact, we believe that it goes against the fundamental principles of preventing, detecting, and punishing corruption. And as a matter of fact, 7 countries, state parties to the Anti-Bribery Convention, have received recommendations to ensure that the effective regret offense does not apply to the foreign bribery offense. Now, a few facts, key facts about enforcement on this slide. As you can see, a lot of progress has been made towards full implementation of the convention. But obviously, there's still much work to be done. And this work, we cannot do it alone. That's why the working group continues to engage with countries which are not yet parties to the Anti-Bribery Convention through regional activities or regional programs in Africa, in Asia Pacific, in Eastern Europe and Central Asia, and in Latin America. These OECD regional programs aim to share our experience, raise anti-corruption standards, and also build law enforcement capacity of partner countries. Now, to conclude, I think it's evident that corruption can only be tackled when policies and stakeholders work together. Therefore, the OECD is committed to strengthening its relationship with the UNCAC community. And the OECD welcomes opportunities such as this one to share the experience it has gained through 16 years in monitoring the implementation of the Anti-Bribery Convention. And also, as both our review mechanisms develop, we hope to continue cooperation on the monitoring of anti-bribery measures to ensure that parties to both the UNCAC and the OECD Anti-Bribery Convention can maximize their input to and benefit from these exercises. Thank you for listening.
I should like to thank Mr. Molet for this explanation and this presentation, and I now give the floor to Mr. Aslan Yusufov, Deputy Head Department for Supervision of Implementation of the Legislation on Counteracting Corruption, Prosecutor General's Office in the Russian Federation. You have the floor, sir.
Thank you very much. Thank you very much, Vice President. I'd like to share with you the experience that Russia has in participating in the review process. And the issues that we're analyzing as a result of the first cycle. I'd like to say that the Russian Federation, as a party to different anti-corruption mechanisms, was quite lucky because we were involved in the review mechanism from the very beginning, and we were one of the first countries to participate in the training process on how to carry out the review. And some people were actually joking about the fact that Russia was a guinea pig in this process during the first steps related to self-assessment. And this is why we have a lot of respect for the mechanism, and we have taken many steps in order to ensure that the recommendations and comments that are found in the report as a result of the review, that all of them would be implemented to the greatest extent possible in our practice. Now I'd like to share with you some personal impressions and also make some comments on the mechanism as far as I see it. I think that the mechanism has to deal with a very difficult task which separates it from other anti-corruption mechanisms, for example, those that exist in Europe and in which Russia participates. Now, the fact that this mechanism is of a global nature and that it takes into account the differences that exist in the legal systems of countries representing our multifaceted world. All of this creates a situation where the country reports is a very analytical report that is very close to what I may label a philosophical consideration of the different problems faced by countries at a particular historical juncture in connection with the need to combat corruption as a transnational phenomenon. And I think that the mechanism is quite successful in dealing with all of this. And this is what we have seen from our report. It was a comprehensive report, a report that covers many secondary issues while focusing on the main issues that require solutions. We also participated in the reviews of Niger and Lithuania, and I have to say that we are very pleased with the work of the Secretariat that managed to ensure the consistency in what I called the philosophical approach to a comprehensive review of country situations. And while other regional mechanisms mostly focus on specific areas of combating corruption, for example, public procurement or criminalization of certain behavior, the implementation review mechanism under UNCAC ensures a comprehensive approach while taking into account the different legal systems that exist in countries. And this is something that is very important. And I have to say that I'm extremely satisfied to see that when the review of Russia was carried out, what was taken into account were not simply the particular features of the Russian legal system, but what was done was a timely consideration of the recommendations that we made during other reviews under other mechanisms. And I think this is very important for all countries, that we have this type of approach to looking at corruption-related issues, for example, the issue of criminalization. When we received recommendations related to the need to criminalize in the Russian legislation certain issues related to corruption, for example, active and passive bribery, what was taken into account were the recommendations made by Greco, recommendations that were made earlier. And this is something that really facilitated our work. These recommendations did not contradict the previous one and were seamlessly introduced into this set of recommendations that were made. And this relates to questions related to promises of a bride, and this was close to the recommendation made by Greco, a recommendation to separate the proposal, bribery proposal or promise of bribery. And those who are making these recommendations found that Russian legislation does not have this clear separation between the two acts in its legislation and in practice. And in order to implement this recommendation, a joint letter of the Investigative Committee and the Federal Prosecutor's Office was prepared that was based on the understanding of this issue as reflected in the recommendations for legislators on the implementation of UNCAC. This is an official document which is part of the convention, and it's available on the UNODC website, and we took the definitions from that document and applied it to our own situation and included it in our legislation, and we gave instructions to prosecutors and investigators how to qualify such acts in line with our own legislation. And when we were preparing that letter, we worked closely with the Supreme Court of the Russian Federation. We considered the position of the Supreme Court. And I would also like to say that the decision of the plenary session of the Supreme Court that sums up the practice related to combating bribes and other corruption-related crimes in 2013, the qualification of these acts related to giving and promising a bribe were made. Some other very specific recommendations were also made, and one of those was the need to improve the specialization of investigators of the investigative committee. And on the basis of a decision of the head of the investigative committee, we have taken measures to improve and increase the specialization of investigators. In connection with corruption-related crimes, we increased the number of staff, investigators dealing with corruption cases in the most difficult areas of the country, for example, Moscow, St. Petersburg, and the Chelyabinsk and Murmansk Oblast, among others. What is also important, we find, is cooperation in legal affairs. And we've seen in the documents that were prepared by the Secretariat something that we find very important. And again, this is also a philosophical approach to the issue. And looking at the systems that exist in the world and separating those where the convention is applied directly and in those countries where the convention is applied through existing country systems. And such a separation very often requires the introduction in national legislation certain measures that will eventually provide, among other things, for the need to ensure bilateral and multilateral cooperation. What was also recommended to us is indeed to continue with the practice that we already had to sign bilateral and multilateral agreements and ensure cooperation in different areas. And the convention actually covers many issues related to international cooperation. And we see as our main goal in bilateral and multilateral agreements to do nothing that would contradict the spirit of the convention, but on the contrary will help us promote the spirit of the convention, especially in those areas where our legislation may have certain gaps. And what we are trying to do is to ensure that when there are differences in the legislation of Russia and other countries, that these differences would not prevent bilateral cooperation. And that is indeed the main objective of our agreements with other countries. And since the review process was completed, the General Prosecutor's Office has concluded relevant agreements with Spain, China, Panama, and the Czech Republic. In addition, we are also focusing on special programs of cooperation that includes the exchange of experience and what is now mandatory as part of these cooperation programs, which cover many issues. But what is mandatory now is the need to look into cooperation on questions related to corruption-related crimes and asset recovery. And such programs have been implemented with Vietnam, Greece, Italy, Cyprus, China, Romania, Croatia, and other countries. The Ministry of Internal Affairs of Russia in 2014 concluded an agreement with the relevant competent authorities of Slovakia and Palestine, and these agreements also have provisions related to combating corruption. And finally, another recommendation, and of course, last but not least, equally important, is to ensure reporting related to corruption-related requests. We now have separate reporting, something that did not exist in the past, and we introduced amendments in the orders of the General Prosecutor of the Russian Federation that identify the parameters of such reporting as part of international cooperation. And also, after recommendations made by the OECD, we also introduced changes into our reporting form, where we have a separate column related to bribery of international public officials. And over the last year, we received 126 requests. In fact, we sent 126 requests to other countries requesting cooperation, and we have received 47 requests from other countries. Now, since the adoption of the report, we now introduce in every request that we make a reference to the convention. And of course, depending on the area of requested cooperation, we can also refer to other instruments, bilateral and multilateral agreements, but we always make a reference to the convention. I think this sends a very good signal. And meetings like this one help us share the different experience and enhance our cooperation, ensuring that we'll be even more effective overcoming the difficulties that may arise from the direct interpretation of internal legislation or international agreements. And in conclusion, I'd like to now thank the Secretariat for giving me this opportunity to make my presentation and to have this exchange of views, and for a very interesting report, the report that was published on the website of the Office of the General Prosecutor of the Russian Federation, and we also published the conclusions of the review as well. Thank you.
I thank Mr. Yusufov for the valuable information presented regarding the experience and review of Russia. And now I give the floor to Mr. Ahmed Tawfiq, Senior Officer of the Corruption Eradication Commission in Indonesia. You have the floor, sir.
Thank you, Vice President, distinguished delegates, ladies and gentlemen. Thank you for giving Indonesia the opportunity to speak under this item agenda and share with all delegates our experience in the implementation review mechanism of UNCAC. In these short presentations, I will share challenges and opportunities of the IRRM in the first cycle undertaken by our country, including on how we manage, respond, and adopt the recommendations. Allow me to begin by highlighting Indonesia's commitment to fully implement the conventions. Since we ratified UNCAC under Law No. 7, year 2006, Indonesia has made several initiatives and activities to assess and sustain the implementation of UNCAC. In 2006, after ratifying the convention, we started by conducting a gap analysis, followed by voluntarily participating in the UNODC pilot review program in year 2009. We became country under review of the first cycle of UNCAC implementation review in 2010. In this cycle, we also became a reviewer for Republic of Iran, Haiti, and Kyrgyzstan. We do aware that the main challenges in conducting the review process is how to build awareness and sense of ownership in Indonesia stakeholders. One of the key is how we can encourage all competent stakeholders to actively participate in all phases of the review. From Indonesia's perspective, it is therefore important to involve all key stakeholders, including civil society, in three most important phases of the review. They are self-assessment checklist, country visit, and finalization of draft report. In the review process, the need for the reviewer to have a comprehensive understanding of Indonesia implementation of UNCAC is important. We would like to express appreciation to the UNODC Secretariat for facilitating effective communication channel between reviewer and country under review. Indonesia believes that country visit plays an important part in order to build comprehensive understanding to both sides. In the country visit, the reviewer will be able to meet and have constructive discussion face-to-face with all stakeholders needed. In our case, each stakeholders were allocated in specific session or issues, so it will lead to identification of specific needs to specific articles. Next, please. It is clear for Indonesia that the review mechanism had given Indonesia benefit. Not only the recommendations, which is very valuable to strengthen our fight against corruptions, but in the other hand, by doing all review process together in coordinated manner, Indonesia has successfully created awareness and ownership of all stakeholders in Indonesia. And how we respond and adopt the review recommendations. Indonesia adopt in two channels. First, in the national strategy on preventing and combating corruptions. And second, in the more technical action plan under presidential instructions, which is in yearly basis. Those two approaches are targeted to strengthen legislations and building capacity. Please allow me to highlight examples on how Indonesia Action Plan responds and adopt recommendations. In the area of management of asset recovery, the recommendation is to ensure complete management of seized, frozen, and confiscated property. And these recommendations adopted in the draft of asset forfeiture law. In the area of bank secrecy, the recommendation is to ensure the bank secrecy can be overridden by other agencies effectively. And these recommendations follow up by developing more effective communication channel especially between law enforcement agencies, financial service regulator, and financial service provider. Also involving financial intelligence unit in the process, conducting training and capacity building. This is when the President of the Republic of Indonesia launched Presidential Instruction number 7, 2015 on 26 May 2015. In conclusion, I would say that Indonesia has benefited from the first cycle review mechanism. From our perspective, keeping the principles enshrined in the terms of reference under Resolution 3/1 is important. Ladies and gentlemen, I thank you for your attention.
أشكر السيد أحمد على إيضاح القيم.
Many thanks to Mr. Ahmed for the important presentation presented and the important steps taken by Indonesia during the review cycle. I also thank the distinguished panelists for their valuable interventions. I now invite delegations to take the floor regarding the implementation of chapters 3 and 4 of the Convention, including on the progress made and impact of the mechanism. I look forward to hearing your views on these issues, particularly from the focal points of the states under review and government experts from the reviewing states which have participated in country reviews of the mechanism. Before I give the floor to the delegations, I wish to ask delegations that wish to take the floor to inform my colleagues in the Secretariat to have their names listed. And now I give the floor to Yemen. Thank you, Mr. Chair. This is the first time that the Republic of Yemen takes the floor, so allow me to express our condolences to the families of the victims of the plane crash. I also wish to thank the Russian Federation for hosting this conference, and we also wish to thank the UN Office on Drugs and Crime for the excellent organization. Allow me to seize this opportunity to thank the Higher National Committee to Combat Corruption, to thank the judges, experts, and UNODC for the huge efforts that were undertaken in order to conclude the executive summary in spite of the difficulties faced by Yemen. This in order for Yemen to keep up with the countries that have already completed their executive summary. Ladies and gentlemen, we reaffirm the fact that the Convention necessitates using all available means and methods, including legislation and the establishment of committees and organs to combat corruption. Such challenges to combat corruption are numerous and as diverse as the means and methods of corruption. Therefore, the Republic of Yemen has strengthened the efforts of all organs and governmental authorities, especially the Ministry of Justice and the Judiciary. In this context, a special prosecutor's office was established to investigate corruption crimes, in addition to increasing the efforts to establish special courts and public prosecution offices, and enhancing the role of auditing councils. International cooperation is also a main priority for the government of Yemen for asset recovery and for the implementation of the convention. Therefore, the Republic of Yemen has established a special legislative system for asset recovery and taken a number of measures, including a special law on the recovery of public funds. Currently, the Higher National Committee to Combat Corruption is updating a national strategy for 2015-2019. In conclusion, the Republic of Yemen looks forward to additional regional and international cooperation in the context of implementing the convention. I thank you.
أشكر ممثلة.
I thank the representative of Yemen, and I give the floor to the representative of Algeria.
شكرا سيد الرئيس.
Thank you, Mr. Chair. The convening of our conference coincides with the end of the first review cycle. It is normal for this session to be a ripe time to evaluate the previous cycle and to look into adequate solutions for some important and critical issues, not only for the next cycle, but also for the future of the implementation of the convention as a whole. During the first review cycle, we have seen some practical and organizational matters that need to be solved in accordance with the general objectives and principles of the convention. Mr. Chair, the current review mechanism is the fruit of a consensus and a balance between the global nature of the convention and the specificities that are geopolitical and legal for member states. Mr. Chair, my country has participated in the first cycle and reviewed 2 countries. It also underwent a review cycle within the determined timeframes. Here, I would like to refer to the fact that in spite of the fact that the terms of reference do not make it obligatory to accept a field visit and disseminate the results of the review, Algeria was very transparent in dealing with the review mechanism and received the field visit and published the report in full. In fact, this would not have been possible without our full confidence in the objectivity of the review mechanism. I also wish to refer to the fact that the review for us led to a real self-assessment process. We spared no effort to take into consideration the recommendations of the review. Several measures were taken, including a review of the penal code and including a new chapter for the protection of witnesses and experts, and that in accordance with the provisions of the convention. My country has greatly made use of the dynamism of the convention and of the review cycle that has first helped to raise awareness as to the importance of combating corruption, not only amongst official committees and authorities that participated, but amongst the public at large. Secondly, there's a better means to collect information on corruption and thus a better knowledge of the dimension of the phenomenon. Thirdly, in updating the national legal system to combat corruption and issuing a special law to combat corruption. This law was based on the UN Convention and included new provisions such as illicit enrichment and recognizing penal sanctions of foreign judicial authorities. Fourthly, it established special bodies to prevent and combat corruption. Such results, we believe, are very positive. We therefore look forward with great optimism to the next cycle, and we hope that it will be launched in due time. We also welcome all the practical proposals that will improve the effectiveness of the review mechanism. At the same time, we do not want this mechanism to become a means to hold countries accountable. We would like it to be a useful and valuable tool for self-assessment and exchange of good practices and technical assistance. I thank you. I thank the representative of Algeria and give the floor to the United States.
Thank you, Mr. Chair. We actually would like to cede our time back to the conference. Thank you.
Thank you. I now give the floor to UNCAC Coalition.
Oops. Thank you, Mr. President. On behalf of the UNCAC Coalition, let me reiterate our condolences to the Russian people and the families and friends of those who lost their life in the recent tragic events. Our thoughts are with you. The damage that corruption causes is tangible and real and needs to be addressed. Many delegations have pointed to this impact, and rightly so. We are particularly concerned with the damage caused to societies at large, the damage that takes place at the collective level. These damages need to be repaired and can't be left unattended. We seem to be better at dealing with the consequences of natural disasters than with those of human-made disasters like corruption. We wouldn't imagine leaving the victims of typhoons, earthquakes, or hurricanes unattended, and yet we often leave the victims of corruption unattended. The missed education and health investments, the justice that was not administered, or the judges left without resources to act, the bridges badly built, or the highways connecting to nowhere. The diminished trust in the institutions, the lack of safety and protection of the citizens, the more expensive milk for children in childcare centers, the increased violence caused by despair and distrust. As enforcement efforts to step up prosecution are taken, efforts which are definitely needed, we also need to step up our action in addressing the consequences that corruption leaves behind. Fortunately, the UNCAC, in its articles 34, 35, and 53b, require and expects states to do so. The summary reports of the reviews during the first cycle reveal most countries, if not all, have some mechanisms of redress in corruption cases. The start of the second phase would provide the chance to review in detail the use and application of Article 53b in regards to collective damage caused by corruption. The even better news is that there are indeed some prosecutors, judges, lawyers, anti-corruption commissioners, and civil society organizations in here and out there, working to make sure that the victims of corruption don't remain as such, and that the damage that corruption causes is repaired. We will be talking about some of those examples actually today during the side event to be held together by the Costa Rican delegation and the UNCAC coalition in Room D, so we would encourage all of you to join and share with us other examples and experience to let those experiences be known. So yes, there are some initiatives and experience, and we encourage you all to do more, to use that framework that is there and make a concrete difference to the life of citizens that have suffered from corruption, both at the domestic and at the international level. Fighting corruption can be an end in itself. It should translate in an actual improvement of the life conditions of citizens in each of our countries across the globe. But also, yes, there are challenges in addressing redress and compensation for corruption. Are there remedy mechanisms in each country ready enough to address collective damage? Do they grant access to civil society? How to measure the damage and provide evidence for it? How to ensure compensation is properly used in a transparent and accountable manner? We need to foster exchange among judges, prosecutors, practitioners to work together and solve these challenges. The answers to these questions will certainly be different for each country. We at the UNCAC coalition will be helping all those of you interested in knowing more, in addressing these challenges, and in doing more about this. The framework for dealing with the consequences of corruption and compensating for the damage is there. We encourage you all to use it and to share your experience. We encourage you to explore in detail your own applications of Articles 34, 35, and 53B, and examine whether those enable effective reparation and compensation of collective or social damage. This can also be an area of technical cooperation and support, and is certainly, in our view, an area of further work. Thank you, Mr. Chairman.
Thank you very much. I give now the floor to Transparency International.
Thank you, Mr. Chair. I would like to extend our condolences to the Russian people for the tragic loss in the recent air crash. The United Nations Convention Against Corruption is a landmark international anti-corruption treaty and a key instrument for overcoming corruption around the world. Its negotiation and ratification by 177 countries is one of the most outstanding achievements in the field of anti-corruption, providing a global response to a global problem. Transparency International has actively supported the convention from the early days, beginning with the Vienna negotiations in 2001 to 2003, and we participated in the 2003 signing conference in Mérida. We have emphasized all along that a follow-up monitoring system would be needed to ensure effective implementation of the convention by governments. And we have played a leading role in the 6-year effort that resulted in the adoption of the review mechanism at the 3rd Conference of States Parties in Doha in 2009. Transparency International and its national chapters have closely followed the implementation review process since it started operating in 2010, and we have prepared overview reports for the first 3 years of review. It is important to recognize that the implementation review mechanism must deal with daunting challenges that are orders of magnitude higher than of other anti-corruption treaties. These result from the Convention's extremely comprehensive scope and its worldwide membership of countries with large differences in political and legal systems. What has been accomplished in the last years is impressive, but the process is still evolving. We would like to make some recommendations in terms of the existing mechanism. No follow-up process has yet been established to address the implementation by governments of the recommendations made in the country reviews. Without timely follow-up, it is not possible to ensure that the recommendations are acted upon and that the purpose of the review process is achieved. This conference should call on state parties to prepare national action plans to respond to recommendations made in the country review reports. These action plans should be submitted to UNODC, the peer review countries, and the implementation review group, as well as published on the UNODC website. We recommend also that efforts should be made to find ways and means to overcome the problem of delays in the country reviews. One of the ways to do that would be to increase the resources of UNODC to enable the Secretariat to provide adequate support to the country reviews. About 110 executive summaries have been completed and published on the country pages of the UNODC website. About 50 full country reports have now been published on the UNODC website, which is a welcome development. We call on states parties to make public the country review reports as well as government self-assessment reports on the UNODC website and also publish them on national websites. UNODC should invite governments to grant this authorization in a positive step to increase public understanding about the review process and the convention. The rules for observer status for non-governmental organizations in the implementation review group and other subsidiary bodies, we believe, are not being respected. NGOs have been denied admission as observers to the implementation review group and the intergovernmental working groups on asset recovery and the prevention of corruption. This exclusion is based on unfortunate objections and has resulted in the establishment of briefings for NGOs on the outcomes of the review process, which have taken place successfully on 3 occasions. The briefings did result in useful exchanges, but were not adequate substitutes for granting observer status to civil society organizations. The COSP should clarify that civil society representatives are able to participate as observers in all COSP subsidiary bodies as provided by the rules of procedure. In particular, the COSP should clarify that civil society representatives are able to participate as observers in the open-ended intergovernmental working groups, as well as in the implementation review group. And with regard to the working group on prevention, should it continue to exist, should call for that working group to proactively solicit civil society views on the implementation of Chapter 2 on prevention, including Articles 10 and 13. In this connection, it should be noted that the working groups do not form part of the implementation review mechanism and therefore are not subject to any special arrangements that were made in connection with the implementation review group. It should also be noted that it is common UN practice for UN open-ended working groups to hold open meetings with NGO observers, whether in Geneva or elsewhere. The COSP should include, therefore, a standing agenda item on civil society participation at every Conference of States Parties session until civil society organizations are admitted as observers in COSP subsidiary bodies. Subsidiary bodies should also be tasked with the collection, reporting, and consideration of civil society experience and recommendations. We have submitted a paper to this conference outlining some of these proposals and also including a number of points that, building on the existing terms of reference, would ensure increased transparency and inclusion of civil society, parliamentarians, and private sector representatives, academia, and others in the UNCAC review process. And that includes publishing reports online and including timetables for country visits and for UNODC to prepare periodic status reports on progress with the review process that include reference to civil society contributions. And there should also be a process of follow-up to country review recommendations in which national action plans are developed with the participation of civil society organizations and published on the UNODC website. Thank you very much for the opportunity to speak today.
Thank you very much. I give the floor now to the representative of Japan.
Thank you, Mr. Chair. First of all, we would like to express our appreciation to all panelists for fruitful and informative presentations. Japan believes that in order to launch successful second cycle, the lessons learned should be fully reflected. The lessons learned identified through first cycle are at least following 3 points. First, overburdening experts and practitioners conducting the review. Second, overburdening the secretariat that may or may not lead to the PBI. Third, the first cycle is not fully completed within the original time frame. Mr. Chair, therefore, we would like to recommend following 2 measures. First, streamlining self-assessment checklist and introducing the word limit for answers. Second, it would be important to consider extending the time frame of the second cycle into 6 or 7 years based on paragraph 47 of the terms of reference. I thank you, Mr. Chairman.
Thank you very much. And I give the floor now to the representative of the United States of America.
Thank you, Mr. Chair. The United Nations Convention Against Corruption's review mechanism has served a critical role over the past 5 years in helping promote the effective implementation of the convention. And the United States is committed to a smooth transition of the review mechanism to its second cycle at this Conference of States Parties in St. Petersburg. In this context, we continue to support the compromises reached in 2009 regarding the modalities and the terms of reference for the review mechanism. At the same time, we have learned important lessons over the last 5 years that need to be addressed as we prepare for the next cycle. As part of our commitment to the terms of reference in the Conference of States Parties, it is important that we comply properly with paragraph 13 of the terms, which requires an affirmative decision of the Conference of States Parties to launch the second cycle, given that all reviews initially of the 144 states parties at the start of the first cycle are not yet complete. It is also important to my delegation, Mr. Chair, that we also comply with paragraph 47 of the terms of reference, which state that the conference shall determine the duration of each review cycle and decide on the number of states parties that shall participate in each year of the review cycle, taking into account the number of states parties to be reviewed and the scope of the cycle. In our view, Mr. Chair, those 2 issues, the number of states parties to be reviewed and the scope of the second cycle, are different than the first cycle. In this context, Mr. Chair, we recommend that this Conference of States Parties finalize a resolution to improve the effectiveness of peer reviews conducted during the second cycle of the review mechanism and take measures to guide the smooth, efficient, and productive operations of the Secretariat over the next 5 years or more. We welcome the Swiss draft resolution that has been presented this week as a vehicle for considering this decision. The United States is willing to examine a wide array of proposals on how best to strengthen the mechanism during the second cycle, while at the same time protecting the existing modalities and terms of reference. I will briefly highlight a few suggestions from my delegation in this regard. First, we propose that the sixth Conference of States Parties approve the launch of the second cycle here in St. Petersburg, and that we empower the next meeting of the Implementation Review Group in June 2016 to facilitate the drawing of lots that would determine the year in which each state party will be reviewed. Secondly, we believe that targeted improvements can be made to the IRG to improve its effectiveness as an analytical and steering body for the mechanism. In particular, we have proposed that the drawing of lots be led by the Extended Bureau and conducted in an open and transparent fashion, rather than dedicating limited translation resources and meeting entitlements at the IRG for this purpose. The drawing of lots could also be webcast live in order for states parties who are not represented in Vienna to view the proceedings online. Third, we believe the revised self-assessment checklist, which currently stands at over 100 pages without a single answer from the responding state, remains too long and unwieldy, and it should be possible to either use the revised checklist that has been the product of consultations over the last few years, or to make reasonable adjustments to the questionnaire format to reduce the burden on responding countries, without eliminating any provision or chapters from the scope of review during the second cycle. Mr. Chair, we also believe that the conference should take appropriate steps to conserve resources and minimize delays in finalizing country reports during the second cycle. Of particular note, placing a page limit or a word limit on national responses to the checklist and a limit on supporting documentation provided by a country under review would help reduce the cost of translation and would help ensure that each country can finish its review in a timely manner. Mr. Chair, in this context, it may also be appropriate in the context of Article 47 of the Terms of Reference to discuss the practical implications of country reviews and the logistical constraints around their completion, given the larger scope of material covered during the second cycle, the delays that have been experienced in finalizing the first cycle, and the overall growth in the total number of states parties. We welcomed the information provided by the Secretariat to the Implementation Review Group this week in St. Petersburg on the ability of states parties to carry out first cycle reviews within the 6 months of the indicative country timeline predicted in the terms of reference. The United States, in fact, exceeded our indicative timeline and took upwards of 2 years to finish our first cycle review. The Secretariat reported that the recent average for other states parties, based on data collected during the first cycle, was approximately 12 to 18 months, which significantly exceeds the indicative timeline on which our work plan and budget is based for the second cycle. We therefore should consider whether our original timeline for the second cycle is still manageable for the current group of states parties, and whether any adjustments to this logistical timeline might help diffuse its total cost over a longer period of time. In this context, based on paragraph 47 of the terms of reference, the United States has proposed that we examine the possibility of carrying out the second cycle over 6 or 7 years, since that is the likely timeline by which the Conference of States Parties may finish all first cycle reviews. In addition, Mr. Chair, we recognize that Article 40 of the terms of reference calls for the second phase of the mechanism, after both the first and second cycles are completed, to require states parties to submit formal updates on progress achieved in connection with observations in its previous country reports through the review mechanism. We support this process. However, we also believe there would be value in using the IRG or the COSP itself to encourage states parties to share lessons learned and to provide verbal or written updates on efforts they have made to implement recommendations from the first cycle. We should not allow the last 5 years of hard work by all states parties to end without some form of continuing and meaningful engagement on chapters 3 and 4. This would be consistent with ongoing efforts by the IRG to carry out Decision 5/1, in which the conference requested the IRG to collect information to facilitate assessment of the performance of the mechanism and to dedicate an agenda item on its future sessions for that such discussion. Finally, Mr. Chair, we believe that the conference should also clearly identify non-responsive parties and identify a path to engage and assist them with fulfilling their obligations for both the first and second cycles. Mr. Chair, regardless of the direction we take this week in St. Petersburg, we must be cognizant of the realities we all face, both at home and within the UN system, regarding the human and financial resources that are available to support the mechanism. In this context, it is important to note that while the official documentation by the Secretariat for this agenda item in document CAC/COSP/2015/6 notes that, quote, states welcomed the estimate of the resource requirements for the functioning of the second cycle, which was presented to the Implementation Review Group at its 6th session. The final report of the 6th session of the IRG, which is CAC/COSP/IRG 2015/5, actually states that some states parties noted that an increase in regular budget and program budget implications were not acceptable, and that some speakers called for strengthened measures to increase cost efficiency, including through the further streamlining of work processes. My delegation was one of these speakers. Here in St. Petersburg, we have an obligation to ensure that the mandates provided to the Secretariat are sustainable within UNODC's current financial and staffing levels. At home, we have a duty to engage our authorities who are responsible for prevention and asset recovery to participate fully in the next cycle, but also to ensure that the mechanism does not detract from their ability to apply chapters 2 and 5 in a meaningful way. We are confident that we can achieve these objectives this week, and we look forward to launching the second cycle here in St. Petersburg. Thank you, Mr. Chair.
Thank you very much. That was my last speaker on the list, actually, of item 2. And now, if you allow me, I would like to thank the panelists for their valuable introduction and the study that we heard from them this morning, and also for the delegation who gave them their views, actually. So I'd like, after that, to close the item. So item 2 is closed. ننتقل الآن إلى البند الثالث.
We now move on to item 3 of the agenda, technical assistance. The conference had decided in resolution 3/1 that the implementation review group was to follow up and continue the work previously undertaken by the open-ended intergovernmental working group on technical assistance in recognition of the fact that technical assistance is an integral component of the review mechanism. The conference, in resolutions 3/4 and 4/1, endorsed a country-led and country-based integrated and coordinated technical assistance delivery as an effective vehicle for the further implementation of the Convention. It encouraged donors and other assistance providers to incorporate those concepts and capacity building into their technical assistance programs, and called on the UNODC to provide technical assistance for the implementation of the Convention. Distinguished delegates, today you have before you a note by the Secretariat entitled Technical Assistance in Support of the Implementation of the Convention to Combat Corruption and Document
CAC/COSP/2015/2.
This background paper is intended to provide a brief overview of technical assistance already delivered by the UNODC in line with resolutions 3/4 and 4/1. Moreover, it aims to give a preview of further activities that the office is planning to implement in the near future. Furthermore, in resolution 4/1 and pursuant to paragraph 11 of the terms of reference, the conference recommended that states use the review process to identify technical assistance needs, preferably arranged according to priority. The conference further requested the Implementation Review Group to consider information on trends in technical assistance requested. The note by the Secretariat.
CAC/COSP/2015/4
entitled Analysis of Technical Assistance Needs Emerging from the country reviews, contains consolidated information and the analysis of needs emerging from the review process and priority areas in technical assistance identified by states under review during the review process. To this end, the Secretariat will provide updated information and analysis of technical assistance needs identified in the country reports. Distinguished delegates, I will now give the floor to the Secretariat for these two updates in terms of item 3 of the agenda. You have the floor.
Thank you, Mr. Vice President. Distinguished delegates, as has been highlighted by the Vice President, technical assistance remains pivotal to the successful implementation of the Convention and has been one of the most important impacts of the implementation review mechanism. I shall begin the briefing on technical assistance with an overview of the note entitled Technical Assistance in Support of the Implementation of the Convention that the Vice President has just referred to. In line with Conference Resolutions 3/4 and 4/1, technical assistance delivered by UNODC for the implementation of the Convention takes into account the importance of a country-based and country-led, integrated and coordinated technical assistance delivery, and follows a three-tiered approach at the global, regional, and national levels to ensure synergies and efficiency. UNODC has strived to ensure a global presence to be able to respond to technical assistance requests. Staff members at headquarters are complemented by field-based staff in high-demand regions. Since 2011, UNODC field-based anti-corruption advisors serve as key focal points for the provision of anti-corruption technical assistance at the regional and country levels. Currently, UNODC has regional advisors for South and Southeast Asia, West and Central Africa, the Middle East and North Africa, Eastern and Southern Africa, Central America and the Caribbean, the Pacific region, and for small island developing states. Furthermore, national advisors have been recruited to provide dedicated advice and support in Mozambique and El Salvador. Staff from headquarters provide both support to the regional advisors as well as direct technical assistance in response to requests from countries inside and outside of these regions. It should be recalled that UNODC technical assistance activities in support of the implementation of the Convention, including the work of many of the professional experts required for their delivery, are financed through extra budgetary contributions. The support of donor countries has remained stable, reflecting confidence in the effective program delivery. The first cycle of the implementation review mechanism has shown that support provided early in the review process can play a key role in ensuring higher quality review reports and better defined technical assistance needs. Further, many states parties sought technical assistance either before or during the reviews to bring them into compliance with the Convention. In taking forward the recommendations emerging from the review process and the technical assistance needs identified, UNODC has adopted a two-pronged approach. The first prong is ensured by providing direct technical assistance, as has been described. The second part of this approach is ensured by seeking and engaging the larger development assistance community. In effect, in the face of an ever-increasing number of technical assistance requests, UNODC is increasingly seeking a strategic approach to its delivery of technical assistance by coordinating and cooperating with other assistance providers. Thus, over the years, UNODC has developed and intensified its technical assistance delivery through partnerships with the World Bank in the Stolen Asset Recovery, or STAR, initiative, as well as in piloting a partnership with the World Bank to take forward the recommendations from the reviews, and in the implementation of a joint anti-corruption project for the Pacific with UNDP, as well as other complementary global projects with parallel work plans with the UNDP. A complete list of all of the organizations with which UNODC regularly works can be found in the technical assistance note that's before you. UNODC continued to promote the ratification of and accession to the convention through targeted awareness raising and advocacy efforts, as well as through the provision of technical assistance in those countries that are not yet states parties. Of the 9 countries that have ratified or acceded to the convention since September 2013, 5 were assisted by UNODC during the pre-ratification process or immediately thereafter. Particular efforts were made in Asia and in the Caribbean and the Pacific. In order to reinforce advocacy efforts in the Caribbean, a second regional pre-ratification workshop was recently delivered in coordination with the CARICOM Secretariat. Ratification workshops were also held in the Pacific with the support of the joint UNODC-UNDP anti-corruption program and with the Global Organization of Parliamentarians Against Corruption, GOPAC. Post-review support is another area where UNODC delivers technical assistance, and to date, UNODC has supported the efforts of some 30 states parties to follow up on their reviews, in particularly by preparing action plans for the implementation of the recommendations from the review, as well as developing training programs to meet some of the needs and gaps identified. UNODC continues to ensure that such processes remain country-led, so that the expertise remains available beyond the formal review process, thereby allowing for states to develop their own capacity to monitor existing gaps, review progress, and reassess compliance with the convention on a regular basis. Assistance was also provided in several cases for the preparation of the review of implementation of Chapters 2 and 5 of the convention. Such assistance included training, the early preparation of the draft self-assessment checklist, as well as other forms of technical assistance to implement these chapters. More detailed information on this aspect of assistance provided can be found in the report on the status of the implementation of Conference Resolution 5.4, as well as the progress report on the implementation of the mandates of the Working Group on Asset Recovery. The legal assistance provided to states parties is multifaceted and ranges from commenting on specific anti-corruption draft laws to supporting the drafting of the actual legislation, the elaboration of codes of conduct or asset declaration systems, the establishment of anti-corruption bodies and financial intelligence units, as well as more cross-cutting issues such as mutual legal assistance and extradition. In the last 2 years, UNODC has provided this type of assistance to some 27 states parties. Capacity building through training reflects the bulk of UNODC's efforts to ensure that the expertise remains and is retained within the national structures. A number of different thematic areas are addressed in this capacity building and include, as a few small examples, supporting the efforts of states to develop national anti-corruption strategies which are implemented and effective, training on specialized skills to investigate and prosecute corruption in some 33 countries, or supporting regional networks to recover assets derived from corruption, which is done primarily through the STAR initiative. At the regional level, UNODC continued to support regional associations of anti-corruption authorities and networks of anti-corruption agencies, such as the African Association of Anti-Corruption Authorities, the East African Association of Anti-Corruption Authorities, and the Network of National Anti-Corruption Institutions in West Africa. Furthermore, in cooperation with the Cambodian Anti-Corruption Unit, UNODC organized a regional meeting in Southeast Asia on curbing foreign bribery that brought together 65 participants from all ASEAN countries as well as from Australia, Japan, and Timor-Leste, and international organizations. I would like to end this part of the briefing by highlighting the development of 2 technical assistance tools as examples of how these can facilitate technical assistance delivery. On Tuesday afternoon, the Resource Guide on Good Practices in the Protection of Reporting Persons was launched here at the conference. This guide addresses one of the most commonly identified technical assistance needs in country reviews, namely in relation to Articles 32 and 33 of the Convention. At the request of states parties, UNODC has also produced a wide range of tools related to the prevention of corruption to assist states in their efforts to prepare for the second review cycle. One of these tools, the National Anti-Corruption Strategies, a practical guide for development and implementation, was launched yesterday at a special event at the conference. I will now turn to the presentation in relation to the note by the Secretariat on the analysis of technical assistance needs emerging from country reviews. In its Resolution 4/1, the conference recommended that all states parties, where applicable, in their responses to the comprehensive self-assessment checklists and in the country reports, should identify technical assistance requirements, preferably prioritized and related to the implementation of the provisions of the Convention that are examined during a given review cycle. The conference also decided that the Implementation Review Group should consider priority areas for the provision of technical assistance, as well as consolidated information on trends in technical assistance required and provided. For this 6th session of the conference, the Secretariat has reviewed the 101 executive summaries that had been finalized by August 2015 and the related country reports in order to provide an in-depth analysis of technical assistance needs. Of the 101 states that had completed the executive summaries, 59 had identified a total of 2,202 technical assistance needs as a means of enhancing their implementation of the Convention. The states that identified technical assistance needs included 16 states parties from the group of African states, 24 states from the group of Asia-Pacific states, 7 from the group of Eastern European states, and 12 from the group of Latin American and Caribbean states. States parties from the group of Western European and other states did not identify any technical assistance needs. The 9 articles of the Convention with which are associated the greatest number of technical assistance needs are Article 32 on the protection of witnesses, experts, and victims, Article 46 on mutual legal assistance, Article 50 on special investigative techniques, Article 48 on law enforcement cooperation, Article 44 on extradition, Article 33 on the protection of reporting persons, Article 16 on the bribery of foreign public officials and officials of a public international organization, Article 37 on cooperation with law enforcement authorities, and lastly, Article 20 on illicit enrichment. As agreed by the conference, the comprehensive self-assessment checklist contains several predetermined categories of technical assistance needs. While many of the needs identified during the country review processes fall within these broad categories, states have also identified other needs, which have subsequently been outlined and reflected in the country review reports. In focusing on the needs identified under Chapter 3, a total of 1,559 technical assistance needs were identified by 55 states in regards to the implementation of that chapter. In the previous analyses that have been conducted by the Secretariat, the most frequently identified need for technical assistance overall was for legislative assistance. This could perhaps be seen as a natural consequence of the implementation of Chapter 3 of the Convention, which includes a large number of provisions calling upon states to ensure the criminalization of corruption offenses. However, it is interesting to note that the present analysis shows that the number of needs for summaries of good practices and lessons learned now surpasses the need for legislative assistance. The 3 articles where the number of needs for legislative assistance exceeds that for summary of good practices are Articles 16, 17, and 25, all of which include mandatory provisions for states to take legislative or other measures to criminalize the offenses. A general overview of Chapter 4 shows that 49 states have identified a total of 643 needs in relation to the implementation of the chapter. The 2 categories of needs that were most commonly identified related to the summary of good practices and lessons learned, as well as capacity building. Needs for support relating to legislative drafting were the 3rd most common. Overall, the number of countries identifying technical assistance needs in the reviews analyzed for this 6th session of the conference remains proportionately similar to that conducted previously, in that 59 of the 101 states that have completed thus far are at 58% then of states requesting technical assistance, which is similar to the 60% that had been made requests for technical assistance in the first analysis carried out. Turning to the needs that had been elaborated outside and beyond the predetermined categories, a total of 41 of the 59 states that identified technical assistance needs also specified needs outside the predetermined categories. An analysis of that additional information revealed that the highest priority was the need to establish case management systems or record-keeping databases. The other most frequently identified needs that fell outside the predetermined categories included strengthening their practice, capacity, and resources, awareness raising, and templates or guidelines for extradition and mutual legal assistance. A few states indicated needs related to information technology crime or computer forensics. The variety of the specific needs reflects not only where assistance would be welcome from external providers, but also reflects the efforts of states to identify their own priority areas and to set the path for national action. With the preparations for the 2nd cycle underway, it should be recalled that technical assistance remains a cornerstone of the Convention. In noting that the revised self-assessment checklist for the 2nd cycle of the mechanism, which allows for the insertion of assistance needs and priorities in a freer manner, the conference may wish to consider how technical assistance needs can best be defined in the reviews, including whether the predetermined category of needs should be retained or not. The conference may also wish to consider how technical assistance needs should be identified and elaborated in the next cycle in order to continue to ensure that their overall utility for both technical assistance providers and recipients. Distinguished delegates, that concludes the Secretariat's briefing on this item. Thank you.
أشكر الأمانة على بيانها.
Thank you to the Secretariat for these explanations and this note. And I now give the floor to the representative of the Philippines.
ملاحظاته على
to listen to his observations on item 3.
Philippines.
Thank you, Mr. Chair, for giving me the floor. At the outset, the Philippines wishes to express its gratitude for the assistance provided by the United Nations Office on Drugs and Crime, Bangkok Regional Office, for the drafting of bills on a comprehensive extradition and mutual legal assistance in criminal legislation. Mr. Chair, the Philippines recognizes the essential role of the review mechanism as a valuable tool in identifying specific needs and gaps in the area of technical assistance. the Philippines is cognizant of the fact that corruption is fought in battlegrounds that constantly shift. In this regard, a fair amount of introspection and self-assessment is needed in terms of our national anti-corruption approach and framework. To further strengthen its program on anti-corruption, the Philippines welcomes the engagement of international organizations, particularly experts in relevant fields, to assist us in our national review. Objective findings, particularly on the remaining gaps, and recommendations on how to address them would be invaluable in forming our policies and programs. Finally, Mr. Chair, to improve the capacity of Philippine government agencies in addressing corruption and institutionalizing accountable governance, there is a need to capitalize on advances in information and communication technology in order to develop critical management information systems, operations databases, and efficient feedback mechanisms. Technical assistance in this regard would be highly appreciated. Thank you, Mr. Chair.
I thank the representative of the Philippines and give the floor to the representative of the USA.
Thank you, Mr. Chairperson. The United States welcomes the opportunity to speak on this important agenda item, as we believe technical assistance is a form of constructive partnership that helps advance our efforts to ensure effective implementation of the Convention Against Corruption. To this end, the United States provides a comprehensive umbrella of assistance to help countries in developing and sustaining an array of governmental reforms, contributing to the anti-corruption mission. Our bilateral assistance agency, USAID, has just published a best practices guide to capture anti-corruption assistance lessons learned and to raise the capacity of its personnel to engage in fruitful assistance partnerships. My bureau at the State Department, INL, has published a similar guide oriented towards criminal justice anti-corruption reforms. Overall, the United States has allocated approximately $735 million to anti-corruption and good governance foreign assistance in our 2015 budget year. We provide assistance to support a range of anti-corruption reforms, including creating and strengthening governance and oversight institutions, assisting in the adoption and enhancement of prevention and enforcement mechanisms, strengthening the impartiality and capacity of the criminal justice system, including the judiciary, supporting efforts to increase transparency, bolster the role of civil society, and aiding countries to develop, strengthen, and implement corruption-related laws and policies. U.S. government funding also bolsters regional anti-corruption frameworks and international networks of practitioners. In addition, the United States provides assistance to support rule of law and justice institutions, including integrity and internal oversight mechanisms, criminal investigative and prosecutorial tools and capacity, criminal tax and customs enforcement systems, anti-money laundering reforms, asset forfeiture tools, financial intelligence units, and specialized and vetted law enforcement units. As one might imagine, from this multifaceted inventory, the United States' experience is that a comprehensive approach is more likely to be sustainable and effective. The most successful projects are those that are a partnership, created by in-country consultation and coordination, and on-the-ground program development and delivery. Just as UNCAC takes a comprehensive approach encompassing criminalization, enforcement, and prevention, technical assistance should also support the range of actions delineated in the Convention. The Convention should be used as a key element of the reform process, but we must ensure that we do not restrict the range of options available to support Convention implementation. Assistance efforts should continue on a bilateral as well as a multilateral basis, including through the expert work of the UN Office of Drugs and Crime, but also through a range of other capable organizations, including civil society organizations, based on comparative advantage and the particular circumstances presented. Coordination of assistance should continue to take place principally at the in-country level, and states seeking such assistance should continue to direct requests to existing in-country coordination groups, as well as any bilateral or multilateral assistance provider they choose to seek out. At the same time, the efforts of UNODC and the in-country needs identified through the UNCAC review mechanism should be provided to possible donors and the implementation review group in order to avoid duplication and better inform existing and planned initiatives. We also applaud the UNODC's efforts moving forward with country-specific technical assistance subsequent to the review process, through the development of a prioritized action plan of technical needs, also through discussion of how to meet identified technical assistance needs by establishing a dialogue with potential donors. And finally, through follow-up by UNODC field-based officers and mentors to encourage wider UN and bilateral programming, including through early incorporation into the UN Development Assistance Framework process. We urge states parties to use these and other channels beyond the review mechanism to follow up on all those technical assistance needs identified during the course of the review process. Thank you.
I thank the representative of the USA and give the floor to the representative of Pakistan.
Thank you, Chair. At the outset, I take this opportunity to praise the role of UNODC in helping the developing countries in organizing fruitful country review programs, both as reviewing states as well as reviewed state. The technical assistance is an integral component of the review mechanism and one of the fundamental pillars of the convention. One of the goals of the review process is thus to help states and state parties to identify and substantiate specific needs for technical assistance and to promote and facilitate the provision of technical assistance. It must be highlighted that the review process has impacted the provision of technical assistance, and the peer learning aspect has followed a free exchange of ideas and learning during the country visits and the subsequent engagement of the state parties on a bilateral basis. The matter of technical assistance needs of the government of Pakistan also came under discussion during the recent country review visit, and once the country review report of Pakistan has been finalized, we would be in a better position to identify and report areas of required technical assistance in consultation with the joint reviews of Pakistan and the UNODC experts. However, regarding technical assistance needs, we should follow the bottom-up approach rather than the top-down approach, and needs of the developing countries must be given special priority. Further attention must also be drawn to the needs for state parties to consider how technical assistance needs could best be defined in the self-assessment checklist for the second review cycle. Furthermore, Mr. President, the importance of country-led and country-based, integrated and coordinated programming and technical assistance delivery for the implementation of the Convention must be focused. In this regard, the published country review reports constitute a useful resource to inform technical assistance providers of the needs identified. I'm sure deliberations on this aspect of technical assistance needs in this 6th CSP will help us prepare better for the second review cycle, which shall be launched now with the decision of this 6th CSP. I take this opportunity to thank for a patient listening. Thank you.
I thank the representative of Pakistan and give the floor to representative of China.
Thank you very much, President. It gives me great honor to make a brief presentation on technical assistance. As we see globalization spreading, the need to strengthen technical assistance is recognized by everyone, and China attaches great importance to this work, and we provide assistance to developing countries applying chapters 2, 4, and 6. China has established an authority to combat corruption, which carries out work to help other countries in implementing the convention, and we have organized 5 workshops for developing countries that attach great importance to this work. We had representatives of Pakistan, Nigeria, Hungary, who participated in these training workshops. We have also hosted 45 representatives from ministries from other countries. We work closely with UNDP and UNODC to organize these training workshops, and we attach special importance to this work. And Chinese leaders met with representatives from other countries who participated in these events, and we worked together on anti-corruption legislation, and we also trained public officials in the area of combating corruption. And we exchange experiences, and we organized visits to the provinces in China. Each workshop has a special theme, and we have worked on the basis of consensus. It has been recognized that the participation of the Communist Party in the Central Committee is very important, and we can take targeted measures that reflect the realities of China. And we will continue our work in this area, and we will try to eradicate the causes of corruption. And we have to continue to work to ensure better levels of education there, of combating corruption. We are promoting openness, and we should also strive for better policies of integrity. We have developed new concepts that were presented during these training workshops, and we carried out the exchange of different experience, and these workshops were a very good form of cooperation according to the views of participants, and we'll be enhancing our cooperation with other countries. We'll be using this platform, and all of the participants in the workshop are looking forward to additional events of this nature, similar workshops, and This is the basis that we'll be using in order to create better conditions to fight corruption, and we also are ready to strengthen even further the technical assistance that we are providing to build capacities and strengthen capacities in the combat against corruption of other countries, and we are continuing this form of international cooperation. Thank you.
I thank the representative of China. I do not see any other request for the floor. I therefore close item 3 of our agenda. And before the end of our meeting for this morning, I would like to give the floor to the Secretariat.
A few announcements. There are 2 regional group meetings. There is an EU coordination meeting at 1:15 in Conference Room F, as well as a G77 task force meeting at 2 p.m. in Conference Room CMS. In the afternoon, there are 2 sets of informal consultations that have been scheduled. The first, scheduled for 14:30, is the discussion on Resolution L12, introduced by Austria, and that will be held in Conference Room E. The second, then, is continuing from this morning, the informal consultations on L10, which is the resolution introduced by Switzerland on the review mechanism, and that meeting will be held in Conference Room F. Thank you, Mr. Vice President.
I thank the Secretariat. We adjourn this meeting and resume our work at 3 o'clock this afternoon. The meeting is adjourned.